About 60% of Australian adults don't have an up-to-date valid will, and even more don't have up-to-date enduring powers of attorney. Having a proper estate plan in place gives you peace of mind to ensure that your family is protected. I'm going to talk about a couple of common questions that we get asked about estate plans in Australia. We don't spend a lot of time thinking about the unpleasant things, the inevitable things that happen, such as death, accident, or illness. What an estate plan does is give you and your family comfort that if something happens to you, you get sick or injured or ill, or if you die, that your family and your loved ones are protected. Estate planning is not just for the wealthy. Anyone who owns asset or has a family or loved one should be thinking about what they need to do in the event the worst happens. A properly drafted estate plan will include two things: a will, which deals with your estate after you have died, and an enduring power of attorney, which deals with decision making in the event that you are unable to make decisions for yourself. Generally, estate plans include some other aspects dealing with things like superannuation, existing trusts and company structures, and for people who have children, decision making about their children if something happens to them. If you don't have an estate plan or your estate plan's not up to date, then there's a number of risks that arise. Firstly, people that you don't want could make decisions about your personal matters and your financial matters, and this could include government agencies such as the public trustee. Secondly, there's the risk that people that you don't want could receive benefits from your estate. Thirdly, there's the risk that your estate could be exposed to increased administrative costs. Fourthly, there's a risk that your loved ones can be exposed to significantly more stress than they would if you had a properly drafted estate plan. Anyone can make their own estate plan. There's available will kits to be downloaded or bought from the post office. But like a lot of things in life, if you don't use an expert, there's significant risks if you get it wrong. One of the principal risks with doing it yourself is an estate plan it doesn't come into effect until the worst has happened. You've lost capacity or you've passed away. So there's no opportunity to actually ask you what you were thinking when you drafted the document. And if the document's drafted incorrectly, it may be up to the court to decide what your intentions were. Estate planning documents have very strict requirements. Wills and enduring powers of attorney must be witnessed correctly. They must include certain items, and if they don't, there can be an increased likelihood that either they won't be effective or there may be additional costs to require the court to interpret them properly. We all have different personal circumstances, blended families, children from earlier relationships, trust assets, business assets, superannuation, and a one-size-fits-all approach is not appropriate. Not all financial resources necessarily form a part of a person's estate. A significant amount of wealth these days is held through superannuation, and that doesn't always form part of an estate when you pass away. There can also be significant taxation consequences of not dealing with items such as superannuation properly. Death can also have significant taxation and asset protection consequences for your beneficiaries, and there may be opportunities as part of your estate plan to ensure that appropriate structures are put in place to protect your loved ones. A common alternative to seeing a lawyer is to see the public trustee and have a will prepared by them for free. There's been a lot of news in the last couple of years about the public trustee and their equivalent interstate and some of the things that have been done by the public trustee. In 2021, there was a major report presented to the Queensland Parliament that raised serious concerns about a number of aspects of estates and people who had their affairs administered by the public trustee. Issues such as billing practices, reporting practices, financial reporting were all questioned. The report was damning, and there's been some changes in legislation that has been proposed to try and deal with some of the issues that were raised. A properly qualified and experienced estate planning lawyer can give you peace of mind to ensure that your family is properly protected when the worst happens. A lot of people believe that because they have modest assets or a conventional family situation that they don't need a will. That's not true. If you die without a will, the intestacy rules apply and they will determine how your estate is distributed. And it may be that people that you don't want to receive something will receive a benefit from your estate. So a lot of people think that if you die without a will and leave a partner or a spouse, that they just automatically receive your estate. That isn't always the case, particularly where there's children involved. If you're survived by your spouse and one child, then your spouse will receive the first $150,000 of your estate and then half of the residual value, while the other half will be received by your child. If you have two or more children, your spouse will receive the first $150,000 and 1/3 of the balance of your estate, while the rest of your children will share the balance 2/3. This can then result in situations where you are sharing your spouse is sharing your inheritance with young children, and this can create an administrative nightmare. An enduring power of attorney ensures that people you decide make decisions about two important types of matters: financial matters and personal, which include healthcare matters. While a will deals with your death, an enduring power of attorney deals with situations where you have lost capacity, that is, the ability to make decisions on your own behalf. An enduring power of attorney allows you to appoint attorneys to make two types of decisions: firstly, financial, and secondly, personal. Personal decisions also include healthcare decisions. If you don't have an enduring power of attorney, then an application may need to be made to the appropriate tribunal for orders in relation to your personal and healthcare decisions, and there's a strong likelihood that the public trustee or other government agencies may become involved. I've been helping clients with their estate planning for over 20 years, and our clients have ranged from people from all walks of life: business owners, salaried employees, people with simple circumstances and people with complex circumstances. What they have all found at the end of it is peace of mind and ensuring that their families are protected.